Hi everyone and welcome back. Diving straight into it, software has become an essential part of our lives and we interact with hundreds of softwares on a daily basis. In fact, we run every part of our lives using software. The thing is, all these softwares are created by some person or the other and they deserve some protection for their efforts. In today's episode, I want to talk about how software is protected by the law and more specifically how they are protected by copyright laws. Let's get started. Before we get into the specifics of how software is protected by copyright law, let's quickly talk about what copyright law is. A copyright is an intellectual property right which grants an exclusive right to creators and owners for their original creations. These rights include the right to make copies, distribute, and display their works. For instance, if you are the author of an original book, you will be entitled to the copyright to that book. Copyrights also protect various types of creations, including literary works like books, musical works like music compositions, artistic works like photographs or paintings, etc. The purpose of a copyright is to encourage creativity and innovation and to ensure that creators benefit from their creations. Now, getting back to our discussion on software, amongst the things that are protected by copyright is computer software. Now, according to the various types of cases that have been decided, software can attract two types of copyright. Number one, it is now well established that the literal elements of the software, which are the source codes and the object codes, will be protected by copyrights as a literal work. That means these codes are protected by copyright in the same way that they protect a book, a poem, or the lyrics to a song. Number two, in the case of Navitaire versus EasyJet in 2006, the courts held that non-literal elements of a software cannot be protected as a copyright, but the artistic elements of a computer software can be protected as an artistic work. In this case, the court recognized that an artistic copyright existed in the graphical user interface and the icons of the software. However, the case did go on to say that single-word commands, complex commands, collections of commands, amongst other things, cannot be protected by copyright. Now, there are some important nuances that you need to know about the copyright protection that softwares are granted. One of the most important things to note is that a copyright does not protect an idea or the functionality of a software, and it only protects a specific expression of that software. So for example, if you take a game software, the functionality of that game or the concept behind the game is not protected. Only the expression of the idea into the code and the actual graphical user interface of the game will be protected. This is why you see a lot of games have the same functionality and concept, but their user interfaces will be different. For example, the games Temple Run and Subway Surfer have the same functionality, have the same concept, and have the same gameplay. But their user interfaces are completely different. And presumably the codes behind these games are also completely different. So both these games can exist without violating the copyrights of each other. Another important thing to note is that even if you take an original code and make slight modifications to it, it might be considered an infringement of somebody's copyright. What I mean is, copying a substantial part of another person's code or user interface would be considered a violation of copyright, even if you have made small adjustments to it. Now, if you are the owner of the copyright of a computer software, then the law grants you several rights as the owner of that copyright. These rights include the right to reproduce and make copies of the software, to distribute the software, to make derivative works of the software, and to publicly display the software. But it's also important to note that the ownership of a copyrighted software might not always be with the creator of that software. For example, if the creator of the software develops the software as part of his or her employment, then the owner of the software will usually be the employer. Or if the software has been commissioned by a third party, then that person will usually be the owner of the copyright and not the person who created the software. You can, however, avoid this from happening by making sure you negotiate this at the time of entering into the contract. Finally, the big advantage of copyright over other types of IP is that the protection granted for copyright is automatic. That is, the source code and the user interface of that copyrighted software will be protected the moment it is created. Now, although copyright protection is automatic in most parts of the world, you as the creator or the owner of the software can do certain things to bolster your protection. Firstly, you should include a copyright notice in your code which can serve as a reminder to others that your work is protected. Additionally, you can register your software in countries where copyright protection is registrable, which will act as further evidence of your ownership. So to recap, copyright protection is crucial in protecting computer softwares. It protects the literal elements and the artistic elements of a computer software. And it grants several exclusive rights to the owner of that software. Anyway, that's it for this episode. Hopefully you found this episode useful. Do consider subscribing to the channel if you like this kind of content. I'll see you in another episode. Take care. Bye.